All right, we're all here. Everybody's got their cameras, so we will go ahead and officially start now. It's Thursday, October 17, 2024. We have one case on our Zoom docket. It's case number 23693, Kimball versus Kimball. And you'll see there in one of the little squares, there is a clock. The time shown is your entire time, which it includes any rebuttal time. You don't get an extra 5 minutes. It's there. There are lights that don't necessarily show up as well on the TV screen as they do in person. Typically, we set you up for 5 minutes rebuttal for the appellant. If you want anything different, that's fine. Just let us know before you start. If I see you're going into your rebuttal time and don't seem to be catching the clock, I may let you know that. But whatever you want to do with your time, it's your 20 minutes. You can spend it however you want, as long as you every now and then will answer the questions if we have any. So with that, counsel for the appellant, you may proceed. Just let us know what you want for your rebuttal time.
Thank you, Your Honor. Bill Gressley in Jacksonville on behalf of David Kimball, the appellant, former husband. I would like to reserve 5 minutes for rebuttal. Whether I eat into it or not is always an issue, so we'll see. But that's my aspirational goal.
All right, you may proceed.
Thank you, Your Honor. At the outset, I want to make sure I mention this because sometimes we get away with time. The second issue that I've raised in our briefs, it has to do with child support and attorney's fees, and the position only is that once this court reverses on one or more of the other substantive grounds, those automatically need to be revisited because they're driven by the economics. And once you change, reverse, and remand on one of the economic issues, it's going to impact all the others. The order of presentation in the brief, really, there wasn't any rhyme or reason. It's not like, oh, my greatest issue is this. It's just the ones that occurred to me to be logical. The initial issue that I've raised, and I think is worth taking a minute to go on, is the stacking issue. The facts are set forth on page 6370 of the record, which is the final judgment that's under review here, the amended final judgment, about the parties' relationships. They got married, they got divorced, they spent months and months apart, and eventually got back together from the time that they got divorced, and then filed another petition for dissolution. Was a period of almost 3 years. I've relied on the dissenting opinion of Judge Rowe in the Potter case out of the first to point out that the statute says what it says about what the length of a marriage is. And the judge here said, well, and I'll just quickly read it.
Mr. Grassley,
Yes.
the Potter case, your argument in the trial court was that it was factually distinguishable, but your argument on appeal is that Potter was wrongly decided.
Well, both
have you waived?
No, sir. Because the whole premise for Potter and its progeny is that the court can find a single marriage, even though there is an interruption, if it is, quote, equitable to do so. My legal argument is that Judge Rowe's dissent in Potter should be what drives this court's decision, which is the date of marriage until the date of filing action for dissolution of marriage. And that's not what the judge did here. What the judge did here is he said, based upon the evidence, it shows the parties were, quote, only apart for a short time period before they reconciled. Well, the statute has nothing to do with reconciling. It has to do with date of marriage and date of filing a petition for dissolution. So it's my
and that the relevance of that in this case is whether or not to award permanent alimony. Is that correct?
Well, the judge did not order permanent alimony. He said, I'm going to award durational and rehabilitative in light of the appellee's assertion that she would forego any claim to permanent alimony if my client was ordered to pay for a 4-year college education and 5 years worth of support. And the judge noted that because this is a long-term marriage, permanent alimony would have been presumed and probably granted.
Mr. Grassley, your let's say we agreed with you that the stacking was impermissible. The second marriage is 12 and a half years.
Yes,
Is
sir.
that correct? So would the durational and the rehabilitative alimony still been proper within that 12-year period?
I think that's an assumption that's not tenable, Your Honor, because the judge has done multiple things here wrong. And one of them has to do with the need and ability to pay analysis. And until we know that this is not a 17-year long-term marriage, and we look at the other economic issues, I think.
But you would agree within a 12-year marriage, 5 years of durational alimony would be legally proper, correct? Within the guidelines?
It would be an available option, certainly. But that.
And the same thing with the rehabilitative alimony would still be within that.
Well, I think there's other issues with this, which is that the first mention of needing a 4-year degree in accounting after really not working by choice, except I think it was like 3 hours a week or something, for years at my client's business, has allowed the former wife to have an unwarranted windfall on the amount of alimony. And I know those are legally separate issues, but they are interrelated. I think once we say this is not a long-term marriage, and then we look at what the actual economics are of this entire final judgment scheme, it is not equitable to stack, and it is not economically accurate to claim that my client can afford this and that the former wife should be entitled to it. The supportive relationship issue is also something that needs to be revisited. The judge, Judge Day, in this amended final judgment, makes the assertion or reasons that because you couldn't tell dollar for dollar what the reduced need for alimony was for the former wife, because of the supportive relationship, that it's not important and it's not something he needs to consider. And that's inconsistent with this court's decision in the Klakow case, which is cited in the briefs, which says that the statute requires us to look at this. And I don't think there's any legitimate argument that this was not a supportive relationship.
What is the evidence of a supportive relationship other than, I believe it was the allegation that the former wife was supporting this individual named Hooper during the time the Mr. Hooper was staying in Brooksville? Isn't that the only evidence that you have that you can document as to I guess maybe some ground for a supportive relationship? What else do you have?
We have a pattern over a several-year period of the former wife expending her $400,000 inheritance and traveling wherever Mr. Hooper was. They lived together, and it wasn't just in Brooksville. It was multiple places. They take trips together. She bought him expensive presents. The testimony of I'm sorry, the private detective, I'm sorry, I know the lady, I'm drawing a blank on her name, but she testified extensively as to every time there was a swap off for the child for time sharing, the former wife would come back to her home in Jacksonville, Duval County, pass off the child to my client, and then immediately take back off and go to wherever Mr. Hooper was. It was not just.
So what was the evidence as to statute 61.14 sub 1 sub B, permanent place of abode? What was the evidence that you believe satisfied that Mr. Hooper and the former wife lived in the same permanent place of abode?
I don't think that is a disqualifying event, because what we have here is a person, Mr. Hooper, who travels for work. He goes many different places for his jobs, and the former wife is with him wherever he goes. That's what the evidence showed. So if you're telling me that, or if it's your premise for your question, that if you don't have a single location where you live together, there can't be a finding of a supportive relationship, I'm sorry, you get the vote. I disagree with that analysis, because that overlooks what the reality is here, which is you've got a person whose work, it takes place wherever he gets work. And that was multiple places, and the evidence was overwhelming. The investigator testified at length as to all the different addresses that were used by the parties to live together.
Well, it would appear to me that the investigator testified, and then the appellee testified, and at least from the result of this case, it would appear that the trial judge tended to believe the former wife versus the investigator. Is that accurate?
The former wife did not deny that she traveled and spent all of her money living with Mr. Hooper.
Oh, but the trial judge determined that it wasn't a supportive relationship. So aren't you asking us to reweigh that evidence at this point?
I'm asking the court to do what it did in Clackow and say, my client does not have an obligation to help support a live-in paramour. And that's exactly what we have here. And
Counsel, do you agree that there was conflicting testimony on whether they were in a supportive relationship?
I disagree. I think that's a legal conclusion on which there is argument on both sides. I think the facts show what the facts show, which is wherever Mr. Hooper was, the former wife went there, and she did not take any effort to start an education.
Every time she traveled to go meet him or be with him, was she paying his expenses?
The evidence showed that they were paying different expenses. She supported him part of the time. He stayed with her at the Airbnbs that she rented so she could be where he was. I'm sorry. I think Judge Edwards has frozen. Oh, okay.
I'm just not moving around a lot. So.
That's okay. I apologize, but I didn't want you to miss out on any of this riveting and persuasive oral argument. That's all.
If you look at all the different factors, they didn't have the permanent place of abode. They seemed like if they went on vacations, sometimes he'd pay the majority, sometimes she'd pay the majority, sometimes they'd pay just about equally. I mean, yes, they were going steady for sure. I mean, they were seeing each other frequently, but the whole idea of the supportive relationship is not that they are emotionally supportive, but it's more financially supportive. Either one can support the other, whole or in part. But if you're basically just sharing expenses, do you really get to the supportive relationship?
Well, and I think the other way to look at that is if you're sharing expenses and taking vacations and doing things together, you're having a life with someone else and you're only paying for half of it. But that doesn't change the fact that what she did was used all of her money and time to avoid looking for work, to avoid seeking any college education, which just happened coincidentally to arise as soon as there was a dissolution petition, so that she could be with her boyfriend. I think that under the rationale from the Clackow decision out of this court, she was helping support him, and she's expecting my client to pay the price for that. And that's that our position is that that's not a correct analysis by the trial judge. The facts are the facts. That we're not asking. I'm not asking this court to reweigh the facts. Take those facts and then say, are these people doing what the statute looks at? It has the Clackow case makes a good point, which is you don't have to quantify dollar for dollar what the amount of support is. You just need to see if in fact there is a supportive relationship, and if so, why is my client being asked to have that be not considered as part of his economic obligations? The most substantively detailed problem with this amended final judgment, other than the imputation of income to the former wife, she has done nothing to be underemployed voluntarily. She lost her job with one of my client's companies because their corporate counsel said, if you're in a divorce case with this person, you don't want her on the payroll. So the uncontradicted evidence from the vocational evaluator was that this lady has many years of clerical experience. and she can get a job making $30,000 or $32,000 a year. All she's got to do is go out there. She testified that there were available jobs that the former wife was qualified for, and she had taken no steps to avail herself of that. And told the evaluator that she was thinking about maybe taking some class on community college online, but never did any of that. Presented no evidence whatsoever of any job search because she hadn't made one. She was busy following her boyfriend around and cohabitating with him. The real fundamental meaty issue here is the problem with the trial court's analysis of my client's income. Assuming the judge did not believe a word my client said, what the judge ordered here is legally indefensible. That treating a loan as income is completely irrational. If I borrow $1 million so I can expand my business and then I end up in a dissolution case, if the judge was to say, well, you've got $1 million, so you can give her $500,000 and you can pay alimony with the rest.
Counsel, how many promissory notes were there showing that these
This is
advances?
a two-man operation. Friends who have made decisions about how they're going to finance the things that needed to be financed. Having practiced for 38 years and had a number of law partners, I've had all kinds of deals with my friends that I haven't documented because we trusted each other. And all the evidence showed was that money from the company was used to help Mr. Russo, my client's partner, build a home that he's going to owe back to the company in terms of not taking distributions in the future or bonuses. And my client financed his legal fees the same way. And nobody said that that was not acceptable to do that. What Mr. Hand testified to, my client's CPA, was that usually you see such a thing, but it's a loan to shareholder. It's got to be repaid, and you can't turn a loan into income without recognizing that it's not income. It's not reoccurring income. It's a debt, and it has to be repaid.
You've got about 4 minutes left on your rebuttal. Do whatever you want. It's your time.
Well, I got to finish this thought, and we'll stop. Which is that the judge, the averaging income, when there was uncontradicted evidence that the parties, that my client's business was hammered because of COVID, is incorrect. It doesn't reflect current reality. They had a year where they had no hits on any of their homes. Secondly, treating an investment in a new business as income to my client is statutorily and logically not accurate. If I borrow money to try to start a new business and make more money, that's not income. If the business makes money that you've invested in, then it becomes income. The judge also averaged the K1 distributions, same problem. And if I don't stop, then I'm not going to be able to do this. So I've hit on what I've got, and I'll save the rest for rebuttal. Thank you.
Right, very good. Ms. Sussman, whenever you're ready, you have the floor.
Thank you, Your Honor. My name is Stephanie Sussman with Sussman Johnson and Alvarez Family Law, and I am here on behalf of the appellee, Emily Kimball. I think I'll try to go in the order that Mr. Gressley went in terms of argument, but I would like to start by saying, something I think we all know, which is, the trial court's judgment does come to this court assumed to be correct. And I do believe what Mr. Gressley is doing is asking this court to reweigh or second guess the trial court's decisions, because all of these decisions are discretionary decisions. Surely there must be the evidence in the record to support the decisions, but all of these are discretionary decisions. To start with this stacking of the marriages and the Potter case, Potter was decided in 2021. The majority in Potter specifically addressed the issue the dissent raised, which was, did the statute abrogate this idea that you could stack marriages? And Potter clearly, the majority disagreed with the dissent, obviously, and said, look, when the statute was enacted, the legislature was presumed to be aware of this case law, and if they had wanted to change that, they could have done so. And the policy, which is apparent throughout all of dissolution law in Florida of equity is really what supports the ability to stack those marriages. And so when, clearly it's case by case analysis, very fact specific, but in this case, you have parties who were married from 1999 to 2005, were divorced in April of 2005. In
Ms.
2000,
Ms. Sussman, if the trial court did not award permanent alimony, isn't all this discussion of stacking irrelevant?
I would agree, but because it's before the court, I didn't want to ignore it. But I think to jump to that point, what I would say is, when this case was tried, we were under the old alimony statute. I think if it were reversed, which I certainly don't think it should be, we'd be under the new statute. Either way, a 5-year award even if you only consider the second marriage of 12 years is clearly not inappropriate or outside the court's discretion, is certainly less than what the former wife could have been awarded. So I do agree with the court, but I didn't want to ignore the issue. I think just to say that, which I believe the court's aware, there's a child conceived and born during this brief separation before the parties were remarried, which I think certainly, if any fact would be relevant to consider on this issue of whether the marriage should be stacked, that is probably the most clear fact that the parties intended to resume their marital relationship. So to move on to the financial part of Mr. Gressley's argument, one thing I do want to point out is, the appellant doesn't challenge the determination of the former wife's need in terms of her expenses or the cost of the education. The focus seems to be more on were the parties' incomes correctly determined, and that part of the need and ability to pay. So on the determination of the former wife's income and the imputation of income, I think the law is clear that the trial court was correct. You shouldn't impute income to someone that's more than what they've ever made. And during the marriage, I don't believe there was any dispute that the former wife's role was a stay-at-home parent, even homeschooling the child for a period of time. She worked for the two family businesses. The appellant's characterization of her losing her job with the second business, I think, is a little bit kind to the former husband. He fired her when the second divorce was initiated, leaving her with only the $20,000 a year income she had from the smaller of the two businesses that were created during the marriage. So the former husband created that situation, and then now seeks to cast an aspersion against the former wife as though she was sitting around doing nothing, intentionally wasting money with no intent to move her life or her career forward. And there's all sorts of facts in the records that belie that in terms of the amount of temporary support that the former husband did and didn't pay. And obviously, with the pandemic, that affected a lot of things. So I don't know that, or I wouldn't say I don't know, I certainly don't agree with the characterization that the former wife was just, running around wasting money for the purpose of trying to get more alimony. I think the facts of this case clearly show that was not what was going on here. So, but in terms of the imputation, the vocational evaluator testified, the trial court clearly considered the testimony, weighed it. There's factual findings in the judgment to show why the trial court rejected that opinion. The evaluator admitted that she did not consider the most recent income, and she was not even aware that the former wife had been fired from that second job by the former husband. So there were a lot of reasons for the trial court to reject the vocational evaluator's opinion, and I don't think there's any error here on that point. And so the trial court, considering former wife...
Counsel, if you gave full credence to the voc rehab expert that she could get a job, say, for around 30,000, maybe up to 35, whatever exactly the testimony was, is she obligated to stay in that rather than to seek a higher paying job that that's her goal for going to college? Is she thinks she can get her CPA, or not CPA necessarily, but get a BS in accounting and earn $65,000. Must she forego that and instead work at 30,000?
I don't believe so. I think Florida law is clear that, there's different types of alimony for different reasons, and the trial court has discretion to decide which one is the most appropriate in cases. Even the new statute allows multiple types of alimony. And I think the reason for that is what, the court is honing in on, is that not every situation is the same. And this is a 50-year-old woman who could have easily pushed for permanent alimony under the old statute. And, you know, she made a decision that wasn't what was best for her. And I think the trial court was certainly within its discretion to agree with her and say this makes much more sense going forward for the future. In a lot of ways, I probably benefited the former husband in this case. And so I don't think there's anything in the law that requires someone to just accept their position in life if they have the ability to move it forward. You know, this, I think we have, it's a different conversation if we're dealing with, you know, I don't like throwing out ages. I don't want to offend anyone, but you know, if you're dealing with someone in their 70s who's been married for 30 or 40 years and then expecting that, then them saying they're going to get rehabilitated, maybe there's more question there. But with this person under these circumstances, I clearly think it made sense. And there's nothing in the law that requires her just to take the best job she can get now if there's something better out there for her. And she did present the required evidence, and they don't, the appellant doesn't challenge the award of rehabilitative alimony. There's nothing in the briefs that says the trial court shouldn't have done that. The challenge here is just as to the determination of the length of the marriage, which I don't think has any relationship to the rehabilitative alimony.
Counsel, the final judgment or supplemental second final judgment, whichever one is the governing one.
Yes, sir.
If she has to give evidence to the husband that she's enrolled every semester, and if she doesn't actually get her degree within 4 years, she's got to pay it all back, right?
Yes, sir.
I mean, that's, you know, whether this is some kind of scheme to get a little extra money doesn't seem to hold any water. And I'm not saying Mr. Grassley's saying that, but I mean, this is, you go to school, you get your degree, or you pay all that money back, seems to put kind of a serious spin on things.
Yes, I agree. And again, I don't even see a challenge to the rehabilitative award here in the way I read the brief. I mean, to me, it's a challenge to the length of the marriage, a challenge to the amount of her income and the imputation. But even if the trial court had imputed what the vocational evaluator said, I don't think that would be a bar to still awarding the rehabilitative alimony, because the intended income at the end of that degree is still twice what the vocational evaluator concluded. So I perceive this appeal as a challenge to two things. Was the length of the marriage correctly determined? Were the parties' incomes correctly determined? But I don't think either of those would require reversal of the rehabilitative award. I don't think it requires reversal of any of the judgment, but even if there was some reversal on any of those points, I don't think it implicates the rehabilitative award at all. I think we're really talking about here is the length of the marriage, which I agree somewhat doesn't, I don't want to say it doesn't matter, but even if it is a 12-year marriage, a 5-year award is still less than the maximum allowable under the current statute, and certainly less under the old statute, because it could have been up to the length of the marriage. And so it's a little bit, I don't want to say moot, but it's not as important to me as I think the income issue. And we've talked about the imputation and the determination of the former wife's income.
Let's talk about the former husband's income for a minute.
Yes, Your Honor.
There were two partners in the businesses, or certainly in the one business, where they kept getting money from Everlast, I think it was, and then going out and buying these other businesses. For example, they got $30,000 at least once, maybe more. If both partners are getting $30,000 to invest in the same business, I mean, was there any evidence of an intent to pay the money back to each other, or just go, okay, we each got 30,000, let's move on and see what else we're going to do? I mean, I kind of got a little drift of that more from Mr. Russo perhaps than from Mr. Kimball's testimony.
Yes, Your Honor. So I think there was no evidence that these were true loans, and there's nothing necessarily improper about that. I think anyone that's owned a business, owned a law firm, whatever kind of business, when you have shareholders, there's things you can do, but the IRS does have definitions of what would be considered an actual loan if and when, the time comes for that true up, for lack of a better term, to be done. And both parties' experts really said the same thing, that this is just a cash flow issue to the owners of these businesses. And whenever there's cash flow available, it can or should be treated as income to a spouse, especially when you're determining support. I think Chapter 61 makes that very clear. The case law talking about self-employed spouses makes that very clear, that you have to be somewhat suspicious of a self-employed business owner when they claim they don't have the money to pay support, but they have money to go do all these other things they want to do. And the record is replete with examples of that. The final judgment is replete with findings about that. When you take money out of your business, that's income to you unless it's a true loan. And what you do with it after that is somewhat irrelevant to the question of whether it's income to you. Whether it's a distribution or you call it a loan so that you don't owe taxes on it at that point in time. You can do whatever you want with it at that point. Pay your mortgage, invest in a new business, buy a Mercedes like the former husband did here. And it's so the use of the money, I don't think is the dispositive question on determining whether this is income to the former husband or not. The question is, when it was taken out of the company, was it available to him for whatever purpose he so chose? And clearly here, that was the case. I mean, there were at least, I think, 6 new entities created. All his investment and his personal attorney's fees were being paid with business funds, which that by definition is income to the party. I mean, there's no question whether you're looking at Chapter 61, the IRS rules, like that is income. When you take money out of a business to pay a personal expense, if you don't claim it as income, there may be some issues down the road if someone realizes what you've been doing when it's tax time. But again, there's no loan documents, no note, not even a text message, no indication that either of these people were ever going to be required to pay this money back. And they hadn't. So the course of conduct showed they were treating this as income to themselves, to do with what they chose. They continued to invest in businesses together. So everything they wanted to do was taken care of. But when it came to the former wife asking for support, then all of a sudden, oh, it's not available for whatever purpose we chose. And I do, want to address a couple of the things that were said to that point. The appellant in his argument characterizes this today as, the former wife being on some intentional course of conduct to make the former husband pay. I mean, that's just a complete mischaracterization. You had a woman who had been in a long-term relationship, however long you believe the marriage to be, with a child that was conceived and born during a separation, whose work during those years was for the companies that the husband was now benefiting from and receiving all this money. And she came to court, and instead of saying, I should be taken care of for the rest of my life, she said, I want to go back to school. I want a reasonable amount of support to be able to do that and to live while I do that. And I'm not asking for permanent alimony if the court finds that this rehabilitative plan is appropriate. This was not somebody that came into court and said, I'm entitled to never work a day in my life. This is someone who came to court and said, I want to be able to move on with my life, but I need help to do that, which is the entire purpose of alimony. And I would also say it's the entire reason, in my opinion, that the alimony statute was revised to create more of a motivation for people to not just rely on spousal support for the rest of their lives. And whether you agree with that or not, from a policy perspective, I mean, I think clearly that is built into where the direction of alimony law in the state is, that you want people that can to do what they can to help themselves and support themselves. And that's exactly what the appellee did here. And as we sit here today, I know I'm not going to go into things that aren't in the record, but this case is long from over in the lower court. And, she's still trying to move on with her life. But to say that the way she has been characterized in the argument today by the appellant, I just think is a complete mischaracterization and somewhat offensive, to be honest. But when it comes down to it, the trial court looked at all aspects of the former husband's income as it was required to do. The K-1 income, the W-2 income, the distributions. It listened to both experts who, again, both said the same thing, that this money coming out really probably is income. The court made the required findings about the gross income, the net income, looked at the former husband's financial affidavit, determined what his surplus was. The award to the former wife, inclusive of both the rehabilitative and the durational alimony, was even much less than the total surplus. So if you look at this judgment through the abuse of discretion lens, as I believe we should, I know there's some talk in the initial brief that one of the issues is de novo, which I certainly disagree with, but there's clear evidence to support everything the trial judge did. There's findings to support it. The transcript supports it. The record evidence, there's hundreds of exhibits. There's nothing.
So let me interrupt you for just a minute.
Yes, sir.
Mr. Grassley in his brief says that the trial court obviously just relied on the summary prepared by wife's counsel as to what the husband's income was. Is there any evidence to support that in the record, or did the court go through a detailed analysis that doesn't even quite match up with the wife's summary?
So I think there's all the numbers in the final judgment are supported by evidence in the record, separate and apart from the summary. And I'll be honest, I can't sit here and cite off the top of my head the exact page numbers in the record, but the K-1s, the W-2s, the financial documents from the business, and the expert witnesses testimony on both sides. I mean, both John Howard and Josh Schultz, you know, they testify a lot here in Jacksonville. They're both CPAs. They both mostly said the same thing. And so I think from their testimony and the documents entered on both sides of the case, you know, from tax returns and things, those support the findings. Again, the information in the summary and the judgment is not, I agree with the court, it's not identical to the summary. So, you know, there's multiple statements like that I think are belied by the record, including that the argument in the brief that the trial court didn't even consider the supportive relationship. I mean, there's findings in the judgment that it did, it just rejected it, which I understand the appellant disagrees with, but that doesn't make it legally incorrect. And so, yeah, I think
were there disputed facts, definitely contradictory testimony from which the court could have found that this was not a supportive relationship between Hooper and your client?
yes, I mean, I think the appellee, Ms. Kimball, never like denied that they were in a relationship, never denied that she was going to see him in Brooksville and had the vacation rental there and things. And so I think those facts are largely undisputed, but whether that amounts to a supportive relationship, I think is a different question. There were certainly disputed facts about some of the things the private investigator was testifying to and her characterization of what was going on. This idea that she spent her entire inheritance on Mr. Hooper clearly was disputed. And I don't know that there's actually anything in the record that supports that statement. You know, there were a lot of things she was paying for during the course of the litigation, including the litigation itself. And again, there's a lot in the record about the temporary support she was and wasn't getting. So she certainly spent that money, but I don't believe there's any evidence that supports that it was spent on Mr. Hooper, certainly in whole, or, you know, or really in part. But yeah, the facts were, a lot of the facts were not disputed, but there were some disputed facts. But I think at the end of the day, the trial court's conclusion that the boyfriend-girlfriend relationship in this case didn't amount to a supportive relationship was supported by the record. And I also think it's important to note that all the case law cited by the appellant are modification cases where the former spouse has been in a long-term cohabiting / supportive relationship after entry of an initial judgment. And here you have someone who admittedly had a boyfriend, was not cohabitating with him. They had separate residences, and there just wasn't enough evidence of that financial interdependence for the trial court to conclude it was supportive to the extent it would eliminate her need for the durational and rehabilitative alimony she was requesting. And so I know I'm getting close to the end of my time, and I believe I've addressed everything, you know, based on the record here, the arguments in the brief, and what we've talked about today. We would respectfully request that the judgment be affirmed in all respects, and that the parties go forward without any changes to it.
All right, thank you very much.
Thank you, Your Honor.
Mr. Grassley, you're going to have 3 minutes and 6 seconds to use wisely. So go forward.
Do my best, Judge. At the outset, if anything I said came across as a personal attack on the former wife, I apologize to Ms. Sussman, to the former wife, and to the court. The course of conduct that I was referring to was the fact that she admitted that she had spent, she did dental work, she did something to the house, but she spent the rest of the $400,000 she got following Mr. Hooper. And that was the course of conduct I was referring to. And Ms. Sussman asked us to feel bad for the wife getting fired from her job that she worked 3 hours a week or whatever the minimum was. And this overlooks the fact that the former wife received $250,000 as half of my client's share of the businesses. She got a $25,000 initial payment, gets $5,000 quarterly, $1,500 monthly, and she got $55,000 in the equity, her share of the equity in the former marital home. This is not a poverty-stricken person. This is someone who has already gotten significant sums. Our argument about the alimony amount turns on a couple of things that I want to make sure the court recognizes as my position. One is the income averaging is not proper because it doesn't reflect current reality. It doesn't recognize the impact on the business that COVID had. I fundamentally disagree with Ms. Sussman's assertion that a loan is income. The way that the experts testified was, yes, you show it as a cash in, and you also offset it by showing it as a liability. And that's what the judge just totally ignored. He just assumed that everything that was taken out of the business, even if it was owed back to the business, was income to my client. He averaged the K1s. He took money taken from the business to invest in new businesses as income when it's not income. It's on one hand, it's money in, but on the other hand, it's a liability. So that should not have been done. When Ms. Sussman said, I haven't challenged the rehabilitative, I've challenged the basic underlying concept that paying a 4-year college education and 5 years of support to someone who never expressed an interest in any of this, and which the marriage never contemplated, is an abuse of discretion. And it's also based on ignoring how much money this former wife is receiving. And I just went through the list of what it is. The challenge to the amount of alimony turns on the income averaging and treating every penny that the company received as personal income, including corporate retreats. When I was a partner at Holland & Knight before I started my own firm, we'd have 500-person weekend retreats every year, and that clearly was a corporate expense. And why this was not is not correct. Thank you, Your Honors. I'm out of time.
Thank you very much. We will be in recess and take it under advisement.
Thank you.
Judge.
Thank you.